The Department of Justice just got caught trying to pull a fast one on a federal court, and what they were trying to hide could determine whether millions of Americans can finally own suppressors and short-barreled rifles without jumping through bureaucratic hoops. This isn't some minor procedural squabble. This is the Trump administration's own DOJ actively fighting to preserve gun restrictions that many thought would disappear after the tax dropped to zero. And what they just tried to sneak into the court record at the last possible moment, it might actually prove the opposite of what they intended. Let me walk you through exactly what happened, because this development changes everything about how this case might unfold. So here's the situation. After Congress passed that massive bill and reduced the NFA tax on items like suppressors and short-barreled rifles from $200 down to zero, a coalition of Second Amendment groups saw an opportunity. They looked at the legal landscape and realized something important. If the government can no longer collect a tax on these items, then the entire justification for the registration system, the transfer restrictions, all of that regulatory framework, it potentially crumbles. Think about it this way. The National Firearms Act was originally justified under Congress's power to levy taxes. That was the constitutional hook that allowed the federal government to regulate these specific firearms in the first place. But now that hook has been removed. The tax is gone. So what gives the government the authority to maintain all these other restrictions? That's the core question driving this lawsuit. Gun Owners of America, the Firearms Regulatory Accountability Coalition, several major firearms retailers, and multiple state governments have all joined forces to challenge the ATF on this exact issue. They're arguing that without the tax, Congress has no constitutional basis to keep the registration requirements, the transfer restrictions, or any of the other NFA red tape in place. Now, both sides in this case want a quick resolution. Nobody wants to drag this through a lengthy trial. So they've filed what are called cross motions for summary judgment. Essentially, each side is asking the court to rule in their favor based purely on the legal arguments and evidence already submitted, without needing witness testimony or a full courtroom battle. The DOJ came out swinging with three main arguments in their original brief. First, they pointed to something called the Special Occupational Tax, which still applies to manufacturers, dealers, and importers of NFA items. They claim that even though individual buyers no longer pay a tax, this remaining tax on businesses means the registration system is still connected to tax enforcement. It's part of what they call a web of regulation that supports the overall taxing scheme.
ATF is getting another lawsuit, this time by half of the country.
NRA, SAF, GOA, FPC, NAGR, NASGW. For the first time, we were all working together to get this done.
The NFA tax is officially dead.
The district court judge did in fact grant a motion for summary judgment in favor of the government, so the ATF won at the lower court level.
No more $200 tax stamp on suppressors and short-barreled rifles. We don't have to cough up that ridiculous $200 tax stamp anymore.
You need to be aware of where we're at, but also where this is going in the future as well.
Second, they invoked the Commerce Clause. The DOJ argues that even if the taxing power argument falls apart, Congress can still regulate these firearms because they move across state lines and affect interstate commerce. They even went so far as to claim that purely local activity, like someone building a suppressor in their own home using only materials from their own state, can still be federally regulated. Why? Because they say unregulated local markets would create gaps in the federal system.
Vice President votes in the affirmative. The bill as amended is passed.
Eliminating the tax would turn the NFA into an unconstitutional firearms registry, at least for every item that was zeroed out.
Well, today is the day. The day we've all been waiting on. The NFA tax is officially gone.
Ladies and gentlemen, it finally happened. Congress just passed the so-called One Big Beautiful Bill.
It's not a weapon itself, it's simply an accessory, and they claim that accessories, like suppressors, are not protected by the Second Amendment.
If you carry, train, travel, or even maintain a firearm, this matters to you.
And here's where it gets really interesting for Second Amendment advocates. The Trump DOJ's third argument was that even if both the taxing power and Commerce Clause justifications fail, the NFA still doesn't violate the Second Amendment. They're citing older court decisions to claim that these particular firearms fall outside constitutional protections. This is the Trump administration, mind you, actively arguing in federal court that the Second Amendment doesn't protect your right to own a suppressor or a short-barreled rifle. But that's not even the most controversial part of what just happened.
We were ready with the best possible win given the circumstances, which was the elimination of the transfer tax on suppressors.
The Department of Justice has formally declared a federal gun control law unconstitutional.
I'll celebrate any win we can get because, let's face it, victories in the fight for the Second Amendment don't come easy.
With gun control being implemented in a number of states, even where least expected, this is not a bill that gun owners should ignore.
Open carry has historically been regulated. The U.S. Supreme Court has said those types of regulations would be improper.
They really don't know what to do with this one, which is always a good thing to see.
After the plaintiffs filed their response tearing apart these arguments, the DOJ did something that raised immediate red flags. In their reply brief, they attached a brand new declaration from the ATF. This wasn't just additional legal argument. This was entirely new evidence that hadn't been part of the case before. This new declaration claims that the ATF denied approximately 691 applications in 2025 due to issues related to the special occupational tax.
It would be handed right over to you. You could take it right home. There would be no wait. There'd be no $200 tax stamp. There'd be no chief law enforcement officer notification mandate.
Is a massive deal. It directly goes after the ATF's tactics over the last 2 years.
Finally closes a very arbitrary and authoritarian chapter in the government overreach book. The department.
We shouldn't even be celebrating something as basic as not having to pay a tax on a constitutional right.
The court ruled in favor of the government under the rationale that the plaintiffs here, along with the state of Texas, lack standing to bring this lawsuit.
It said in part that gun regulations must be consistent with the historical tradition of firearms regulations in the U.S.
The DOJ is using this to argue that the registration system is still meaningfully connected to tax enforcement and therefore constitutionally justified. But here's the problem, and this is where the DOJ got caught. Under the rules of the Northern District of Texas, where this case is being heard, you cannot introduce new evidence at the reply stage without first getting permission from the judge. That's a fundamental rule of civil procedure. The whole point of the reply brief is to respond to arguments the other side made, not to shore up weaknesses in your own case by dropping new evidence at the last minute when your opponent can't respond to it. The DOJ never asked for permission. They just attached this declaration and hoped nobody would notice.
So the ATF is back at it again. You'd think after being slapped down by federal courts multiple times, they'd get the message.
Our citizens want gun safety, want firearm safety, want community safety.
But what it would do is essentially it would make a suppressor transferred and owned just like a firearm.
This is a huge win for the Second Amendment, saving law-abiding taxpayers hundreds of millions of dollars.
There's a myriad of things that can tie you up legally, financially, put you in jail, or maybe get you in very serious trouble with the police.
First and foremost, basic gun safety does not have to be a threat to the Second Amendment.
The plaintiffs noticed. They've now filed a motion asking the court to strike this evidence entirely. In the alternative, they're requesting the opportunity to file a surreply, which would give them a chance to respond to this new material that was improperly introduced. And here's the thing that makes this even more damaging for the government's position. When you actually look at what this new evidence says, it completely undermines the DOJ's argument. The declaration claims 691 denials based on SOT issues. But in that same year, the ATF processed more than 2.1 million NFA transfers. Do the math on that. We're talking about roughly 0.03% of applications being denied for tax-related reasons. That's not evidence of a registration system that's meaningfully connected to tax enforcement.
Saying setting a higher threshold in an emergency could mean life or death.
The $200 tax stamp was always nothing more than an arbitrary hurdle, punishing law-abiding citizens for wanting shorter rifles and devices that literally protect our hearing.
For over 91 years, the National Firearms Act taxed these items in an overt and largely successful attempt to discourage law-abiding citizens from purchasing and using them.
First of all, it's important that you know the gun and concealed carry laws in your home state and anywhere you plan to carry.
It's not the gun owner, it's not the pistol permit holders, it's the criminals that are causing the violence and the gun problem.
One less thing gun owners have to worry about. This means you can continue to use them how you've been using them for years.
That's evidence of the exact opposite. It shows that the registration system operates almost entirely independently of any tax collection function. The plaintiffs are pointing this out in their motion. They're essentially saying the DOJ's own evidence proves their case. If only 0.03% of applications have anything to do with tax issues, then the registration system clearly isn't serving a tax enforcement purpose. It's just bureaucratic control for its own sake.
Filed multiple lawsuits challenging the NFA, as well as state bans on suppressors, and we even saw the first U.S. territory legalize suppressors.
Basically, they kicked the ATF in the teeth. They seem kind of punch drunk. They seem as though they got the bell rung pretty bad.
The fight doesn't end until every unconstitutional gun control law is off the books. It's either a fund-generating scheme or it's designed to make it harder for people to carry firearms. That's it.
something happened that almost never happens in American law.
Firearms Policy Coalition has succeeded in their lawsuit against the federal government.
There's another problem with the DOJ's new declaration. It relies heavily on data from when the $200 tax was still in effect. But we're now living under a completely different legal reality. The tax is zero. The DOJ hasn't explained why historical denial rates under the old system have any relevance to whether the current system is constitutionally justified now that the tax has been eliminated. It's like arguing that toll booth operators are still necessary to collect tolls after the tolls have been abolished.
The ATF overreach has been stopped once again.
And there absolutely must be continued pressure on our elected officials.
The Supreme Court just came down with its biggest Second Amendment ruling in more than a decade.
GOA in Texas are pointing out is that the ATF may still be trying to do something sneaky.
If you're going to restrict a constitutional right, it has to be consistent with the nation's historical traditions of firearm regulation.
The ATF and the government is going to fight this every step of the way. And sooner or later, it will land before the Supreme Court.
The historical data about how many people used to get stopped for not paying doesn't tell you anything about whether the toll booths should still exist today. So where does this leave us? We have a federal lawsuit that could fundamentally reshape how suppressors, short-barreled rifles, and other NFA items are regulated. The plaintiffs are making a straightforward constitutional argument. Without the tax, there's no taxing power justification for the regulations, and the Commerce Clause doesn't give Congress unlimited authority to regulate every firearm just because some firearms cross state lines. The DOJ is fighting back with everything they have, including arguments that many Second Amendment supporters find deeply troubling, coming from a Republican administration.
Unnecessary burdens, making it more difficult or almost impossible for people to get and carry a firearm.
Not having this Fourth Amendment to protect you and protect yourself, that's pretty crazy.
We all know we've got more battles ahead. There will be lawsuits, there will be advocacy.
Not every instrument that is bearable will be protected by the Second Amendment.
It's a constitutional right, it's not a privilege. So the ability to carry a firearm should be open to everyone.
They're not just defending the procedural aspects of the NFA. They're actively arguing that the Second Amendment itself doesn't protect these firearms. And now we have this procedural dispute about whether the DOJ followed the rules. It might seem like a minor technical issue, but it matters for several reasons. First, if the court strikes the DOJ's new evidence, they lose one of their key pieces of support for the taxing power argument. Second, it signals to the court that the government is willing to bend procedural rules when their case is weak, which doesn't exactly build credibility. Third, if the court allows the plaintiffs to respond, they'll have another opportunity to hammer home just how badly this evidence backfires on the government's position.
Either all constitutional rights are treated the same, or we don't have any rights. That's kind of how it goes. Full restoration of our rights as outlined in the Second Amendment. That is our goal.
Well, later today, a landmark civil rights case is set to be argued before the Supreme Court.
Half a dozen lawsuits were filed, and now, finally, here we are.
What it does is it opens up the ability for people to be able to protect themselves to everyone.
The judge now has to make a decision, strike the evidence, and proceed with what was properly submitted. Allow the evidence, but give the plaintiffs a fair chance to respond. Or let the DOJ's procedural violation slide and accept the evidence without further briefing. Whatever the court decides on this procedural question, the underlying constitutional issues aren't going away. This case is moving toward a resolution that could affect every American who wants to own a suppressor or short-barreled rifle without navigating months of paperwork and registration requirements. The plaintiffs have strong arguments. The taxing power justification genuinely is weaker now that there's no tax. The Commerce Clause argument requires accepting an extremely broad view of federal power that many courts have pushed back against in recent years. And the Second Amendment argument relies on precedents that may not survive scrutiny under the standards established in recent Supreme Court decisions, but the government has resources, institutional advantages, and a long history of courts deferring to federal regulatory schemes. Nothing is guaranteed. What we can say is that this case just got more interesting. The DOJ's attempt to sneak in new evidence and the fact that this evidence actually supports the plaintiff's position suggests that the government knows their arguments have serious weaknesses. When you're confident in your case, you don't need to bend procedural rules to introduce last-minute evidence. You do that when you're worried about losing. The coming weeks will reveal how the court handles this dispute and whether the case moves toward a final decision. This is one of the most significant challenges to federal firearms regulation in years, and every development matters. That's it for today, folks. See you in the next video.